You don't have to get too formal until you see Ranking Member Johnson come in or till I gavel in without his presence, but we're going to give him a couple more minutes. Whenever possible. The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. Today, we would like to welcome this hearing on digital copyright privacy. I will now recognize myself for a short opening statement. Today, we're exploring the topic of copyright privacy in a digital era. This is not a new subject. Digital Millennium Copyright Act is more than 20 years old, and yet emerging technologies and emerging threat have in fact caused us to once again have to revisit the threat to this great industry. In 2019, the industries involved in copyright employed nearly 9 million people, contributed at least $1.3 trillion to the U.S. economy. Of these numbers, online piracy is estimated to cost over 200,000 jobs and approximately $50 billion to our gross domestic product. And you might ask, well, if they're in commerce, why is it not in our GDP? Because for the most part, it goes to foreign countries and it goes to individuals who will never pay their taxes. Well, copyright piracy used to be involved in back alley sales of ripped CDs, DVDs, or in my day, the bootleg 8-track. Digital copyright piracy now involves vast amounts of infringing content made widely available on the internet. Much of it is given away for free, but not without a cost. The cost often includes the spyware and, in fact, side advertising that pays for giving away your rights free. Unfortunately, many of these websites, like FM Movies, are hosted on servers that exist outside the United States, currently outside our ability to take them down. This creates unique judicial challenges for enforcement against widespread privacy on such websites. In some cases, these websites are even hosted within foreign governments, governments like the Russian government on military bases and other enemies of the United States. It is vital to understand the important difference between websites that happen to have infringing activities, websites that may host those who in fact do not respect intellectual property, and criminal websites who exist only for the purpose of in fact giving away that which they did not buy and have no rights to. In this hearing, we want to explore possible solutions to the worst of the worst, at least a way to minimize the prevalence of this infringing content on these illegal sites. These solutions could include requiring internet service providers to permanently block piracy sites that host only or substantially only infringing content. This is a very small portion of all ISPs, but a large portion of that which is stolen on behalf of these individuals. Dynamic site blocking is to address privacy of live sports and entertainment for set periods of time may also be explored. Working with platforms to remove pirated content as soon as possible to better meet the needs of live sports entertainment. And I want to particularly focus on that here today. I look forward to the witnesses because, in fact, notice and takedown might be fine in a week, a day, or an hour, unless, in fact, the event is only an hour or two long, and 1 or 2 hours means there is no effective takedown in the live broadcast. Given the importance of this issue, I want to thank our witnesses for appearing here today, and I want to say it once and for all. This committee is the committee of jurisdiction. Inaction is not acceptable. We have to find solutions that work for the intellectual property producers, or we will not have the robust industry in the future that we have today. And with that, I'd like to recognize the ranking member for his opening statement.
Thank you, Chairman Issa, and thank you for holding this very important hearing. When the Barbie movie premiered earlier this year, it made $155 million its first 3 days in U.S. theaters. Internationally, it earned $359 million that first box office weekend. And Barbie ultimately brought an estimated 9 million new moviegoers to theaters, according to a pre-screening survey done by The Quorum. Industries like the film industry, ones that are reliant on the exclusive authority to reproduce and distribute creative derivative versions, industries like the film industry, ones that are reliant on the exclusive authority to reproduce and distribute, create derivative versions, and publicly perform a copyrighted work, contributed $1.29 trillion to the U.S. GDP in 2019. As the viewing public, we often hear the most about those top-line numbers. That's because box office scores and tales of sold-out theaters make the news, but they are only a part of the story. Of those in this room who joined the crowds to see Barbie in theaters, I bet few, if any of us, sat through and watched as the credits rolled. If we had, we would have read the names of just a few of the myriad individuals required to make a movie. Yes, the film studios are the primary rights holders of the copyrighted work, and the actors and directors get most of the world's attention, but there are so many more people whose livelihoods depend on the success of a film. Technicians, writers, musicians, carpenters, engineers, artists, programmers, and so many more add up to constitute the film industry. The U.S. film and TV industries support and are supported by millions of individuals employed by those sectors. In 2019, copyright-intensive industries in the United States employed 6.6 million individuals directly and 2 million more people through indirect employment. I say this all not to diminish the importance of box office success, far from it. But it is important for us to remember that copyright law does not just support the bottom line, but also the small creators and industry workers. Copyright law itself may have little to do with driving a truck or feeding hungry studio workers, but these are some of the people hurt by piracy of copyrighted works. Digital piracy of film and television has increased since 2020. Between January and August of 2022, there were 141.7 billion visits to copyright piracy sites worldwide. Piracy has caused an estimated annual loss of between 230,000 and 560,000 jobs in the United States, and between 47.5 and $115.3 billion in reduced GDP. These are staggering losses to our creative fields, and they impact not just the stars and studio executives, but the many individuals who work in the industry. When industries cannot afford to pay competitive salaries, students look to different fields. Piracy of copyrighted works is not a new problem. What began as pirated DVDs back in the 1990s became a torrent of files in the 2000s. Torrent files have now become streaming. Today, more than 80% of digital video piracy is conducted via streaming, where copies of movies, television, and other copyrighted content is available in real time over the internet. Congress has acted to protect copyright-dependent industries before. From the moment personal computers landed in homes around the world, we knew content piracy would be a concern. That's why Congress passed Section 512 of the Digital Millennium Copyright Act in 1998 to provide the opportunity to protect copyrighted works on the internet. I'm looking forward to hearing from our witnesses how notice and takedown works today, what challenges exist in removing pirated content, and how changes in technology and the internet itself have impacted how we think about copyright protections overall. I would also note that I know the stakeholders are not limited to the people in this room, and when Congress sets about to solve or even examine an issue, we need to look at all the facts and hear from everyone. We must approach any issue before this committee with the seriousness and diligence it deserves. I'm certain that my chairman will do that. This hearing is, however, an important first step to examining the problem of copyright piracy. Finally, welcome to our witnesses. I look forward to hearing from you today and appreciate your willingness to testify before us. I thank the chairman once again, and I yield back the balance.
I thank the ranking member. Without objection, all other opening statements will be included in the record. It's now my pleasure to introduce our witnesses. Mr. Richard Gladstein is an Academy Award-nominated producer and executive director of Brooklyn College Graduate School of Cinema and president and founder of the motion picture production company Film Colony. He has produced or executive produced films such as The Hateful Eight, Pulp Fiction, the one that all of us know of, The Cider House Rules, Finding Neverland, among others. Welcome. Mr. Rish McKnight, McKnight, is General Counsel of the Ultimate Fighting Championship, or UFC, and Executive Vice President, Deputy General Counsel, and co-head of litigation for Endeavor. In addition to being the UFC's parent company, Endeavor owns and operates a number of other businesses spanning sports, entertainment, advertising, and talent representation. Mr. Matthew Shears. Mr. Shears is the president of the Computer and Communications Industry Association, where he leads its advocacy on behalf of the internet, communications, and technology companies. He is also co-founder and board chair of the Digital Trust and Safety Partnership, which develops best practices to foster a safer and more trustworthy internet. And a returning champion, to use the UFC terminology, Ms. Karen Temple. Ms. Karen Temple is now the Senior Executive Vice President and Global General Counsel of the Motion Picture Association, where she oversees the association's legal affairs, content protection efforts around the world. But we knew her in her previous roles as the U.S. Copyright Office, most recently Register of Copyrights. Prior to leading the U.S. Copyright Office, Ms. Temple headed the Office of Policy and International Affairs. And I want to take just one more moment. All of you are distinguished, but to have somebody who has looked at clouds from both sides now, so to speak, having been so key to determining copyright and how it is to be inherently protected by government, and now seeing in one of the most fiercely competitive areas the stealing of copyright, is a real honor, and I want to thank you for all of your service in both roles. And with that, I have to swear you in, and then we can begin. If you'd please rise to take the oath. Raising your right hand, do you solemnly swear or affirm, under penalty of perjury, that the testimony you're about to give will be the truth and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect that all witnesses answered in the affirmative. Please be seated. We will now begin with Mr. Gladstein.
Chairman Issa, Ranking Member Johnson, and distinguished members of the IP Subcommittee, thank you for your invitation to speak with you today on behalf of America's creative community. As the chairman said, I'm a filmmaker and educator. I produce such films as The Bourne Identity, Finding Neverland, She's All That, The Cider House Rules, Pulp Fiction, among many others. I'm currently the executive director at Brooklyn College's Fierstein Graduate School of Cinema, a part of the City University of New York, where we are educating the next generation of diverse storytellers. Film and television production benefits a great many of our cities and states. On average, for each and every day of film shoots, approximately $250,000 is contributed to that local economy. Small films generally shoot for about 24 days, and large ones for over 70 days. Throughout the U.S., our film and television industries employ approximately 2.4 million Americans. These numbers bear out what I have always known in my heart to be true. Creativity is not just an important part of American life, it is a backbone of our nation's cultural and economic strength. Despite being a robust engine for the U.S. economy, our industries have been besieged by digital piracy since the inception of the internet, and we've been fighting these illegal activities with hands tied behind our backs ever since. I'm not here today to speak to issues concerning fair use or the use of clips from films or television shows, or the ways in which ideas or content are used by others in similar works. Rather, I'm going to confine my thoughts to the wholesale theft and distribution of our movies and TV shows by criminal enterprises, not facsimile or parts or replicas of our work, but rather the entire and actual film or television program. Large-scale piracy operations today are criminal enterprises. They create internet sites that look deceptively similar to legitimate streaming services, A recent study found that as many as 30 million Americans use these illegal streaming services, often without realizing they are doing so. The damages are significant, as another report found that piracy causes losses of at least $29 billion and as much as $71 billion each and every year. It's also been proven that digital piracy costs the U.S. economy between 230,000 and 560,000 jobs every year. The vast majority of these job losses and revenues affect the workers behind the cameras, the production designers, costume designers, cinematographers, caterers, and every member of their crews, including seamstresses, carpenters, electricians, and more. These are well-paid, skilled jobs for craftspeople. They often do not require a 4-year college degree. Many look at us as large corporations, but these individuals, again, the backbone of our industry, are mostly freelance and a part of the gig economy. 92% of the businesses in film and television employ fewer than 10 people. Our workers' pension and health plans are funded by residuals. These residuals are derived from revenue and profits from movies and television shows. Piracy is eviscerating these profits. So, why are we allowing hundreds of thousands of American jobs to disappear each year? The truth is that most of the piracy happening in the United States is occurring through illegal services that are based overseas and beyond the reach of U.S. law enforcement. And although there are laws in place around the world that have proven to be effective against piracy, these tools are not yet available to us here in the United States. One such effective tool allows courts to issue no-fault injunctive relief, or site blocking, creating orders that direct internet service providers, after a full judicial process, to block access to offshore websites that are found to be dedicated to piracy. This tool is effective in more than 40 countries that have implemented it, including in Western democracies like Canada, the UK, and Australia. There is a decade of evidence to support its effectiveness. Numerous studies have shown that this tool reduces traffic to pirate sites while also increasing traffic to legitimate and legal sites, the sites that actually result in fair compensation to creatives for their work. Early objections to site blocking erroneously said it would be abused, could cause harm to free speech or break the internet. Creatives like me are fierce advocates for free speech, and we would never call for this important right to be blocked. When piracy is diminished with effective laws, film financiers and creatives will be able to realize the revenue they are entitled to. As my time is running out, I will say that in sum, I'm here to request that Congress find reasonable solutions, such as site blocking, in order to curtail the theft and distribution of our creative work. Those engaged in illegal behavior, as well as internet intermediaries that consistently aid and abet such theft, should be stopped and face penalties. Thank you for your invitation to speak with you and your consideration of my testimony.
I thank the gentleman. We now go to Mr. McKnight.
Chairman Issa, Ranking Member Johnson, distinguished members of the subcommittee, thank you for inviting me to testify today. My name is Rashay McKnight. I am Executive Vice President and General Counsel of the Ultimate Fighting Championship and Deputy General Counsel and Co-Head of Litigation at Endeavor, one of the world's largest sports, entertainment, and fashion companies. I am honored to testify about the internet piracy challenges that UFC faces as a provider of popular live sports content. UFC appreciates working with Congress on this issue, including the enactment of the Protecting Lawful Streaming Act in 2020. UFC is a preeminent content creator that hosts and airs live mixed martial arts content, including through a pay-per-view option in the United States in partnership with ESPN+. UFC events are beloved and highly anticipated. As explained in my written statement, a critical element of UFC's content is that the essence of the event often involves highly impactful but very brief moments in time, such as a knockout in a fight or a well-executed move. These key moments frequently last only minutes or even seconds. Because UFC's content is so popular, UFC faces pervasive piracy of its live content. Pirates record the live streams not just through holding their phones up to a screen to record a UFC event and live stream it, but also through more sophisticated techniques, resulting in HD quality video. The pirates also brazenly advertise on social media platforms to get viewers to come to their pirate websites with slogans like "Watch UFC free." When people learn that they will be able to access UFC content for free, they have no reason to purchase UFC content for your pay-per-view. The problem is not unique to UFC. UFC recently submitted a joint letter with the NBA and the NFL to the U.S. Patent and Trademark Office that highlighted the challenges we all face with respect to the piracy of live sports events. By one estimate, the financial impact of online piracy across the global sports industry is up to $28 billion in additional potential annual revenue. UFC estimates that online piracy diverts multiple millions of dollars from legitimate purchases of UFC's content each year. In turn, this results in a substantial loss of tax revenue and harms sports providers' ability to host events that benefit local businesses and communities. UFC does the hard work to submit thousands of takedown requests to a variety of online service providers during and immediately after each UFC event. It is also engaged in outreach to individual platforms. However, despite these efforts, piracy persists. You have heard from and will continue to hear from my co-panelists about site blocking, and UFC supports those efforts for the reasons that have already been discussed. UFC has also identified a few additional solutions that I will talk about today and that would significantly help address the problem of piracy of live sporting events. First and foremost, OSPs do not remove infringing live streams and videos expeditiously, as is required for them to attain a safe harbor from liability for the infringement of their users under the Digital Millennium Copyright Act. In fact, infringing live streams often stay online for a full UFC event. UFC has found that OSPs exploit a lack of clarity in the DMCA as to what it means to remove content expeditiously, which clearly must account for whether the request is time sensitive. To put matters concretely, for each UFC pay-per-view event between January of last year and this past November, UFC sent thousands of takedown requests on average, even putting aside infringing content that was automatically removed by certain OSPs. For live stream content, 26% of infringing UFC content was permitted to stay up for longer than 1 hour after request, a significant portion of a live event, and approximately 6% of content was permitted to stay up for longer than 5 hours. It is not uncommon for these streams to collect hundreds of thousands or even millions of views while they are available. Congress can and should clarify that at least for time-sensitive content like live sports events, expeditious removal means that infringing content must be removed instantaneously or near instantaneously. It is not enough if an infringing live stream is left up until the live content ends. Second, many OSPs have not adopted an effective process for identifying and terminating repeat infringers, as is also required for them to have a safe harbor under the DMCA. Too frequently, UFC sees that after a user is terminated for repeat infringement, that same user will create new accounts that are obviously connected to the previous account. Clarification is needed that a reasonable repeat infringer policy would, among other things, involve account verification measures that prevent the creation of new accounts by the same person and other measures that would limit the ability of very newly created accounts to live stream for a certain period or reach a widespread audience of viewers. We recognize this continues to be an ongoing conversation requiring input from all stakeholders, and we hope to be able to work with you and the members of this subcommittee going forward. I want to thank the subcommittee again for giving UFC the opportunity to testify today. I'd be happy to answer any questions you may have. Thank you.
Thank you, Mr. Chair.
Chairman Issa, Ranking Member Johnson, members of the subcommittee, thanks for the invitation. It's good to be with you again today. My name is Matt Shears. I'm president of CCIA. For over 50 years, CCIA has been a voice for information, communications, and technology firms. Products provided by our members connect and empower users around the world, enabling work and study and commerce and entertainment for billions. In so doing, the digital sector is a proud and critical partner to the creative industry. Widespread adoption of technology products and services have created entirely new markets for the legal consumption of content, permitting users to lawfully enjoy digital media nearly anywhere at any time, generating more revenue opportunities for creators than have ever existed before. And tech companies are themselves IP creators, spending hundreds of millions of dollars on premium award-winning content and millions more licensing content from others for lawful distribution. As leading providers of content and licensees, they understand well the value of that investment. It is the case that a small minority of bad actors misuse digital tools to infringe IP rights, and the digital sector shares the goal of preventing this. But we must achieve this goal without interfering with legitimate online commerce, communication, and the Constitution. The most powerful tool to prevent infringement is ensuring that consumers can lawfully access the content they want, where they want it, when they want it, on the device they want it, and products provided by American tech leaders are making this possible. Now, in addition, CCIA members regularly engage with rights holders to identify and enforce against infringers, including through extensive content moderation systems that go above and beyond the notice and takedown that's currently contemplated by federal law. Now, automated filtering is not always effective. It relies on third-party input, granular information. It can be misused, and it can result in over-removal and over-enforcement of against non-infringing content and fair use, thus suppressing lawful expression. So automated systems do require human oversight and pairing the right solution with the problem to ensure they function properly. Policymakers should be wary of the proposal for online enforcement that's DNS-level site blocking. This approach involves interfering with the basic architecture of the internet to suppress content. And this blunt instrument of architectural regulation is inherently imprecise. It cannot be achieved file by file or even country by country, but instead disappears entire sites for the entire world. This puts far more speech at risk of suppression, similar to closing the Library of Congress over a single book. So for that reason, DNS-level site blocking is not technically or constitutionally possible to implement, and certainly not without significant collateral damage. My written testimony describes in greater detail the EU's website blocking system, which is littered with false positives, and it provides an instructive example of the unintended consequences of policy. There's little transparency around blocking orders and few ways to determine when content is being withheld from the public by court order. This is why technological experts like ICANN and the Internet Society have strongly advised against DNS-level blocking. Now, election season is upon us, and it's prudent to recall that political speech is frequently a target of wrongful copyright allegations. In the last presidential election, multiple candidates were prevented from live streaming their own speeches due to dubious copyright claims, and campaign advertisements are regularly accused of infringement. Whether inadvertent or intentional, this cannot be tolerated in a democracy. So in conclusion, the more blunt the instrument, the greater the risk to expression. So we must calibrate solutions appropriately. Nevertheless, CCIA members are committed to fighting infringement by investing significant resources in new products that give new opportunities to creators and create better responses to infringement. I look forward to your questions. Thank you.
Thank you. Ms. Temple.
Thank you, Chairman Issa, Ranking Member Johnson, and members of the subcommittee for the opportunity to testify today on behalf of the motion picture, television, and streaming industries. And thank you for the very kind introduction at the beginning. The American motion picture and television production industry is the world leader in this sector, distributing its films and TV shows in over 130 countries. In 2021, the enduring value and global appeal of the U.S. movie industry earned $14.4 billion in exports. Our industry is also a major U.S. employer that supported 2.4 million jobs and $186 billion in total wages in 2021. The topic of today's hearing is an issue of critical importance to our industry and to the many other industries that are part of the creative sector: piracy of valuable intellectual property. Piracy, of course, is not a victimless crime, as you've heard. Piracy of filmed entertainment costs the U.S. economy $29.2 billion and over 100,000 jobs annually. And it does not just affect big Hollywood studios and megastars. It affects everyone who works in the industry, such as carpenters, electricians, and hairstylists, as well as the businesses, as you heard, most of them small businesses that provide related services like caterers, dry cleaners, and florists. In addition, piracy services can directly threaten Americans' personal and financial security, including exposing everyday people to credit card fraud, identity theft, and malware. Take F movies, for example. It's a piracy website that has been blocked in 16 countries and was referred to U.S. law enforcement more than 4 years ago in 2019. But it is still up and accessible to millions of users in the United States. If you would, please turn your attention to the screens. Anyone can simply type the F-Movies URL into their favorite browser today, and an extremely professional and legitimate-looking site pops up. You can literally scroll through thousands of movies and television shows, including this year's blockbusters, and even movies that have not yet hit theaters. You'll see all of our top-rated blockbusters and popular films. Here you see, coming up, Wonka, which won't be out into the United States theaters until this Friday, but it's just a click away on this piracy streaming service. Also notice the ads for slotlights.net. That's an illegal online casino, likely Russian, that is targeting US consumers. Analysis shows that this single piracy site had 168 million visits in just the month of November. Most of these visits come from the United States, accounting for roughly 38% of all users. This means that this site was visited more than 64 million times by people in the United States in just 1 month. As you clearly saw from this video, this is not a legitimate site that might include grandma's home movies or public domain documentaries. This is a commercial scale operation whose sole purpose is to steal creative content and funnel the proceeds back to criminal organizations. If we had site blocking in the United States, as we do in the 16 other countries where versions of this site had been blocked already, then this piracy site's US traffic would have plummeted, protecting US consumers and the US creative sector and removing the financial incentives for piracy. So it's beyond time for Congress to revisit no-fault injunctive relief to combat blatant forms of piracy. When Congress, a decade ago, considered establishing an express authority for such relief, opponents responded with the unfounded prediction of potential harm to the internet. As a result, Congress declined to move forward with legislation. But much of the world enacted these tools despite the overheated rhetoric. More than 40 countries, including leading democracies such as the UK, much of Western Europe, Canada, Australia, India, and South Korea, have enacted no-fault injunctive relief regimes that expressly authorize courts or administrative agencies to issue orders to ISPs to block access to websites dedicated to piracy. These laws work. They dramatically reduce visits to piracy sites. Even more important, they result in more visits to legal sites. And none of the hyperbolic predictions about the effects of site blocking have come true. Examples of overblocking, that is blocking of non-infringing content or stifling free expression or deprivation of due process, have been rare to the point of non-existence. In fact, none of the examples of purported overblocking that CCIA cited in its testimony actually involved a blocking order to an ISP because of copyright infringement. So I'm here today with some very good news. Effective tools to combat piracy exist. The sky has not fallen, and despite the widespread use of site blocking around the world, the internet is emphatically not broken. Thus, it is time for Congress to consider enacting express authority for a no-fault injunctive regime that will give rights holders what more than a decade of experience around the globe has shown is one of the most effective tools to address piracy. Thank you for your time and attention to this important issue, and I am happy to answer your questions.
Thank you. I'm going to forego my initial round of questions and first go to the gentlelady from Florida, Ms. Lee.
Thank you, Mr. Chairman, and thank you to all of our witnesses for being here today and sharing with us your insights and your expertise. Mr. Gladstein, I'd like to begin with you. During your testimony, you described one remedy that you propose, which is site blocking. That is, directing ISPs to block local access to websites that are dedicated to privacy. You also mentioned that you personally have a strong commitment to the First Amendment and protecting free speech. If you would please elaborate for us on your perspective that site blocking does not infringe upon First Amendment rights to speech and expression.
Thank you for your question. I mean, you just were shown a website that is dedicated virtually entirely to distributing illegal programming that they don't own the rights to be disseminating. Blocking that site from doing what they're doing, the concept that that would be an infringement upon free speech is, I think, a specious argument. If someone were to go and take a bunch of Ford F-150s and steal them and create a lot, and judicial process went in and showed that, you looked at the VIN numbers and you saw that they didn't have the right to sell. So the person that set up this shop to sell these cars didn't have the right to do it. And you went through a judicial review. And you wanted to stop that store from selling illegal merchandise. The concept of saying that free speech would be infringed by blocking their advertising to sell free merchandise, I think is a specious, irrelevant, and it just makes no sense to me whatsoever.
Tell us, if you would, why one of the alternative remedies of the takedown, if the site is identified, having it shut down, why is that different and inadequate instead of the all-out site blocking?
Well, I believe, I'm not an expert at this, and Karen would be better probably to answer, but the laws in which what we're able to do with companies that are U.S. companies versus companies that are international companies is different. But I think Karen
We'll give that to Ms. Temple. If you would share with us a little bit more about your concepts of remedies, no-fault injunctive relief, and the distinction there.
Yes, as he mentioned, the issue that we've been focusing on with respect to no-fault injunctive relief are those websites that are dedicated exclusively to infringement. They are not UGC sites. If we sent them a takedown notice, they are not going to take it down because that is their primary and sole purpose. They are also often located overseas, so the DMCA doesn't even apply necessarily to them. So the only way that we can go after those types of sites is through a lot of civil enforcement, a lot of trying to get law enforcement overseas to actually go after the sites. But if we are not able to get law enforcement overseas and we aren't able to find the website operators wherever they may be, then site blocking is the only remedy we have for the United States. And F Movies, for example, is a site where the operators of the site are actually located in Vietnam. The servers are actually in Bulgaria. I recently went to Vietnam and requested and asked the Vietnamese law enforcement to go after those website operators. Again, we also referred this to U.S. law enforcement, but so far we have not been able to get that site down. So again, millions and millions of U.S. consumers are accessing this illegal content.
And Mr. McKnight, you have a unique perspective on the takedown process given your industry. Tell us, if you would, your perspective on why that is inadequate.
Yes, we think that essentially the speed, and with which material moments occur in live events, focusing on UFC in particular, we may have a main card that features a popular fighter like Conor McGregor. In 5 or 10 minutes, or less, sometimes 5 or 10 seconds, those moments that the fans cares most about seeing can elapse. So if they're able to pirate, a stream for 5 or 10 minutes, they get what they want, essentially taking away any incentive to pay a dime for a legitimate piece of content. And the technology is advancing, not just the means to access the content, but the quality. Some of these feeds, if you look at these pirated sites, are HD quality. They're just as good or close to as good as what you're getting on our site. So our focus is on the definition of expeditious removal. We have evidence, empirical evidence that sites can do better. And these are oftentimes social media platforms, not specifically folks who are dedicated to criminal conduct, but simply folks who have an opportunity and the technology to do better, taking down these illegal streams in a way that we believe is appropriate. They can do it. We think they have a commercial incentive not to always put their best foot forward. And we think in the absence of clarification as to what expeditious removal should mean, which is immediate or near immediate, then they'll continue to not put their best foot forward. And that's the issue we have in the
Would the gentlelady yield for just a second?
Yes, Mr. Chairman, I yield the balance of my time to the chair.
We'll say balance. Just as a follow-up to make sure it's in the record with your questioning, Mr. McKnight, what is the fastest that you've seen takedown occur? Just so that we understand how fast it has been and can be.
Yes, we've seen it happen, in several minutes. That's about the fastest we see it happen. But it's taken sometimes hours, sometimes days. And it's really these fluctuations that give us the proof that, the best foot forward is not always being put forward. We've been told, by a particular platform that at one point we were elevated to kind of most favored nation status, and we saw dramatic improvement for a few weeks, and then things kind of went back to what they were, status quo.
I thank the gentlelady for yielding. With that, I recognize the ranking member for his questions.
Thank you, Mr. Chairman. Mr. Gladstein, what does copyright enforcement in the United States look like for individuals or small group creators who do not have access to resources like the UFC's or the MPA's Alliance for Creativity and Entertainment?
We have various guilds and unions that assist filmmakers of all types, and so they're helpful. But we rely upon the distributors, who are often the financiers of our films, to make the decisions about where our films go. As a producer of Pulp Fiction, I don't get to weigh in on where my film is distributed. I can have an opinion, but it's often not listened to. I think the important thing to cite is that as a creator, the more people that see that very product that I've created thrills me. So there are, I think, 140 legal streaming sites. So it isn't a problem of there's not enough places to find the films in legitimate areas. Studios such as Warner Brothers, Disney, and smaller art house distributors are trying to find the most vast audience that they can find in every corner of the world. And we rely upon those studios or distributors to issue these kind of takedown notices, et cetera. As a filmmaker, it's not something that I participate in. I'd rather create my next movie while someone else is fighting the battle of swiping money from us somewhere else.
Thank you. Ms. Temple, one of the many developments in recent years has been the trend from illegal downloads to illegal streaming. Can you explain what the implications of this shift are?
Yes, thank you for the question. And to add on to what the other witness said as well, in terms of a notice and takedown and, individuals not being able to really protect their rights, I will say that is very difficult. We spend, hundreds and millions of dollars to develop notice and takedown systems, to send millions of notices to various UGC sites. Individual artists and creators often don't have the ability and resources to do that. So it is a very difficult situation for individual creators, and that is something that has often been discussed with respect to the DMCA. I will say that with respect to how piracy works now, we're seeing online piracy, that is streaming piracy now, be the vast majority of the type of piracy that is out there. That is more than 90% of the piracy that is out there is streaming piracy. And the difficulty, of course, as I mentioned earlier, is that it starts outside of our jurisdiction. So the operators are not in the United States. We are able to go after them when they're here. The operators might be in one country. The servers where the infringing content is hosted might be in yet another country. The registrar or registry might be another country's registry that is actually like a .to from Tonga. So it's extremely complicated and difficult for us to actively go after these dedicated infringing sites because of the global nature of piracy.
Thank you. Mr. McKnight, can you explain why this is especially significant for live events like those put on by the UFC?
Yes, as mentioned previously, we think that the short time frame with which material moments can take place in the context of live events makes it ultimately important that platforms are putting their best foot forward and taking down this illicit content as soon as possible. It's the proverbial case of justice delayed is justice denied. So oftentimes, if we're getting takedowns in 10 minutes, 15 minutes, an hour, or certainly days, it's too late. The folks viewing the pirated streams have already seen these material moments, and they've already made the decision that if those are available, they're not going to pay for legitimate content.
Thank you. The Protect Lawful Streaming Act was enacted nearly 3 years ago to close certain gaps that made enforcement of infringement challenging when it was conducted by digital streaming. What effect has the Protect Lawful Streaming Act had on internet piracy so far, Mr. McKnight?
So I think that the passage is certainly helpful. We worked, along to get that passed. We would like to see it enforced because I think that at the end of the day, the true deterrent to folks who are professional pirates, some of which we've been speaking about today, is when they actually see, these laws enforced. So I think it's a huge step in the right direction, and we'd love to see greater enforcement so that, a true deterrent effect can take place in the market.
Thank you, and I yield back.
I thank the gentleman. We now go to the gentleman from Wisconsin, Mr. Fitzgerald.
Thank you, Chairman. Ms. Temple, how does piracy affect the type of films that might be financed or produced? Any opinion on that?
Yeah, that's a great question. Unfortunately, piracy does affect the variety of films that might be produced because it costs so much money to be able to produce a film that you want to make sure that that film will actually be able to get back its revenue. If a film is pirated, if it's an indie film or a niche film, then the revenue that is going to be affected by piracy will even be lower. So unfortunately, that means that you often might see a few more of those blockbusters and those sequels and series types of films because those are going to have a large amount of revenue versus being able to have a wider variety of types of films. And it really does, I think, impact minority filmmakers and independent filmmakers because they are not able as much as some of the larger studios to prevent the piracy that is going on.
Yeah, so the studios are more or less likely to take a risk on a film knowing that the prevalence of that piracy might be related to the content. Does that
Exactly.
sound accurate?
Yes, exactly.
Okay, very good. Mr. McKnight, the area that you've been discussing is fascinating to me, I think to many other people, because of the live stream angle. What financial impact does copyright privacy, do you have any idea what impact it has on the live sports industry per se? Ballpark or any kind of estimate on that?
So we've done studies. You can't do it with exactitude, obviously, because you can't say every single person who looks at a pirate stream is going to convert to a paying consumer.
Right.
Even if you take very conservative numbers, 1 out of 5, you get into tens, to hundreds of millions of dollars in losses. And as Ranking Member Johnson correctly pointed out, the real problem here is a lot of people view this as victimless crimes, but the lack of these resources aren't just affecting an inanimate entity or the wealthy members of that entity. They're also people downstream. They're the athletes. They're people who work the cameras. People who work in just very basic jobs, like in the production crew, driving trucks and doing things of that nature, all of whom are impacted by this loss in revenue.
The other thing I would say is, as someone who, you brought up Conor McGregor, and I've seen a few of his fights, and oftentimes, that results in somebody kind of organizing a party or bringing a group of people together to watch that. And so have you looked at the consumer end of it? Are people aware oftentimes that they may be not on an official site, but on a pirated site? What do people, how do they gauge where they're going to seek their entertainment or a live stream of a sporting event?
So I think people are aware. I think the real issue is, like I said, they view it as somewhat of a victimless crime. If you go on, a social media platform, for example, and someone uploads a UFC fight, you go and you click on the link, you don't view yourself as doing anything inappropriate. What you think you're doing is, getting free access to an event you enjoy, and that the wealthy UFC won't miss the money that's they could be obtaining as a result of a legitimate purchase. But when you multiply that thought process by hundreds of millions of times, obviously the dollars get significant, and then you have that cascading effect on everyone involved up and down the stream of producing that event that I had mentioned before. So I do think they know. They certainly know in the case of folks who are going to the professional pirates, and paying cut rates that are advertising sometimes on the social media platforms, essentially saying, don't buy the event from the UFC, come here and get it for free. And they're doing it in ways that I think it's readily, easily to identify that you're not doing something proper.
In a lot of commercial settings, whether it be a bar or a restaurant or some place where they're actually using it to kind of bring people to their restaurant or their place of business. Have you guys looked at that angle of it? Is this something that's happening and is a violation?
So we do look at that, and we do have commercial licensing agreements with many of these establishments that are showing it at bars and things of that nature, and we have ways to police it when people, are showing it without paying that commercial fee. That aspect of it is actually less of an issue than the individual user going to the social media sites or folks going to these professionally pirated sites where they are, putting these sites up for the specific reason of showing pirated content.
Very good. Thank you very much. I yield back, Chairman.
Gentleman yields back. We now go to my friend and colleague from California, Mr. Liu.
Thank you, Chairman Issa and Ranking Member Johnson, for holding this important hearing. So, Ms. Temple, I have a question for you. You showed F Movies, the online piracy site for movies. If you're in Europe and you typed in that website, would you be able to watch free movies in Europe?
No, and the vast majority you would not, because, again, it's been blocked in 16 countries, including most of the EU. So you would not be able to access F-movies in those places where it has been site blocked through the legislation there.
Thank you. So, Mr. Schurz, I just went on my phone and went on F Movies, and it's still up, and I can watch Willy Wonka for free without paying for it. Why don't the online service providers block it right now, like today?
So I take as described the site that we saw here, though I do have to ask, that might have to do something with why federal law enforcement hasn't taken action against this either. There are, of course, lots of remedies that are available today under existing federal law.
Well, I think the reason is because they're based in Vietnam. But you don't have to take it as described. You can just go on it on your phone right now.
So I think we should take a step back and recognize that if the remedy that is sought is implemented here, all we're doing is preventing a domain name from resolving to an IP address, right?
Right. But I think that's important. So I'm going to ask the members of your organization to take it down right now. So F Movies is so popular, there's a whole Wikipedia site on it. I just read it. It's been in existence since 2016. It was launched 7 years ago. It says what countries have blocked it, what countries have it. Your members can take it down or can block it right now. I'm just asking you to do that because we're trying to be reasonable here. This is such an unreasonable case. It is so clearly online piracy, copyright infringement, and you don't want your organization, your members to be defending something so blatantly unlawful and unreasonable. So I just ask your members to block that site today.
So the broadband providers that actually provide the resolution of these domain names are not at this table. So
right, get them to block the site today. People should block the site today because you cannot defend this. It's just not defensible. And the members of Congress who are watching this, this is not where you want to be. This is not where your industry wants to be. I get the nuances. I may not even oppose the views that you espouse today, but this particular site, for example, is not defensible, and certainly not for 7 years. You did say, like in your testimony, right? You talk about how your organization and your companies work with stakeholders to, deal with copyright infringement. This has been going on like since 2016. It's so clearly indefensible. I'm just asking you all to take it down, to block it.
The digital services that are content creators among my constituents are also victims of these sites. They too distribute content online, and their content is also pirated. So this is a broadly shared interest in preventing infringement. And obviously, the best tool for that is to make content as widely available as possible where and when consumers want it. Meeting consumers' needs is
So that's very interesting. I know you said that, you put in your testimony. Do you think people actually don't know how they can watch the movie Willy Wonka? Do
Well,
you
so
think with internet search, they won't be able to figure out how they can stream it and pay for it?
I think that's a great question because at least as we've been told, Wonka is not yet available in this market, but it's available in other markets. And so we often see that pirates arbitrage windowed releases to try and take advantage of content not being available in one market. And that's why a number of audiovisual producers have gone to worldwide releases. But
So what you're saying is that all movie studios, immediately upon releasing a movie, and the movie studios need to also release it, right, online? And then is that your solution?
what I'm saying is the best strategy to fighting piracy, among many strategies, is ensuring that consumers can access the content that they want to pay for. And we've seen that when lawful services are launched in countries where there is high piracy, those rates go down because consumers, by and large, want to pay for this stuff. They want to consume it lawfully. There's obviously risks to infringing services, and the vast majority of them want to support the creators that they enjoy.
So, thank you. So I asked the members of your organization that can block this to block it, and if they don't exist in your organization, I asked the chair of this committee to call in a hearing with the witness that does represent the members that could block this site and block it now.
Would the gentleman
I yield
yield?
back. Yes. Go ahead.
Pursuant to your request, I will agree to invite, if you will, members of the ISP community here to have a discussion about the proposed remedies and how some or all of them might be implemented pursuant to court orders. So that will be an invitation that the ranking member and I will send out before we get to Christmas.
Thank you, Mr. Chairman. I yield back.
Thank the gentleman. We now go to the gentleman from Oregon, Mr. Benz.
Thank you, Mr. Chair, and thank all of you for being here. Ms. Temple, I'm trying to figure out if this is an issue of technology, that we can fix it, or a lack of enforcement, or something else. So tell me, as we listen to the exchange just previous to my questions, I'm a little bit unclear. So which is it?
Well, as I mentioned earlier, it is a very complicated issue. I will respond to what Mr. Shura said about, access to legitimate content. I think that is an argument that we were hearing 20 years ago, but quite frankly, today, there are hundreds of ways to access movies legally online, through streaming services throughout the world. So there are a wide variety of legitimate offerings for consumers, but piracy still exists. And what makes piracy so complicated and difficult is that technology does change, and we do have to keep laws updated to be able to address the changing technology. As I mentioned before, streaming piracy has become one of the most prolific types of piracy that we have out there. Also, it's cross-jurisdictional, again, so it's difficult to be able to attack the websites where they are. And I think Representative Liu was right when he said that probably the reason that the U.S. law enforcement has not gone after F-movies is because the website operators are in Vietnam. We do encourage law enforcement, and they do work together, but it sometimes takes time and years. And we also went to Vietnam, personally, I went to Vietnam to ask law enforcement to take action, but they have not done so yet. So if we had a solution in addition to the solutions, this is not a panacea. We don't think that site blocking alone is the only solution. We still engage in a lot of self-help, but if we had that additional tool of site blocking, that would allow us to be even more effective to combat piracy today, the way it occurs.
Right, well, you take us directly to my question of what we should anticipate should the ISP folk come in. What are they going to say?
Well, it's interesting because, in our experience overseas, where this has happened in 40 countries, we actually work collaboratively with the ISPs. So we have had great relationships and cooperative relationships with the ISPs because they understand that this is a process that is not overly burdensome to them. It's a process also that they are engaged in. So my hope would be that the ISPs that you would call in would talk to the ISPs in the 40 countries that have this type of legislation, and they would realize that the type of legislation we're asking for is legislation that works, that's effective, and that provides all of the guardrails and due process, issues that have been raised in the past.
We'll see. So let's stick with this for a second. The tools that you suggest, site blocking, ham-handed, not directed. What's wrong with the device?
Yeah, I mean, I certainly, those who are not familiar with with legislation and the way site blocking works could say that is the case. But in our experience, for the last 10 years, that is just not true. The way that site blocking works is, in all of the jurisdictions in which we operate, there is a very specific process. First, to assess whether the website is actually dedicated exclusively
let me
to
hop
infringement.
ahead. Does it on occasion not get it right?
In our experience,
Is it perfect?
well, no law is perfect, so I can't say.
I'm not talking about the law. I'm talking about the technology.
In our experience, as I said, we do not see instances of overblocking or
In anticipating a difference of opinion, Mr. Schurz, maybe you can answer the question.
Yeah, so I think there are a number of examples cited in my testimony and others that we can provide where these architectural level solutions have gone wrong. Now, if we're talking about this one site that we've seen, and this remedy that's being proposed would only be available against that site, then that's one situation. But if this remedy would be available against any online presence that's accused of infringement, well then, would this remedy be available against campaign advertisements that are alleged to have not licensed their music? I mean, we have to ask against what constituency can this be applied, first of all. And then secondly, what's the potential collateral damage? I mean, it may not be remembered, but 10 years ago, due to miscalibration, I understand, of IT, the digital service Spotify was blocked in this building, right? So mistakes happen, and we need to ensure that the remedies are properly scoped for the problem.
Thank you. Yield back.
Thank you, gentlemen. We now go to the gentlelady from North Carolina, Ms. Ross.
Thank you, Mr. Chairman and Ranking Member, and thanks to all the witnesses for joining us today. When artists and creators pour their energy into developing a product or a creative work, whether it's a song, a movie, a book, an article, a piece of visual art, or anything else, they deserve the opportunity to profit from their work. And digital privacy is theft of that opportunity. It deprives not only the copyright holders, but the individual artists and technicians who have contributed to a product of to earn their livelihood and be able to profit from their creativity and their work. This is embodied in our Constitution. Ms. Temple, I know you've gotten a lot of questions about how site blocking works. Which countries have been most effective in executing site blocks while also respecting due process?
Thank you for the question. I think in our experience, the United Kingdom has been very effective in implementing site blocks, but also recognizing and protecting individual freedoms. Australia is another jurisdiction that has extensive experience in this and has been very effective. They recently, in 2018, did a full review of their legislation to see if it had any negative impacts, and continued on with the legislation because it did not. So those are two jurisdictions that we find to be very, very effective.
Just to pick up on Australia, because you cited evidence from studies in Australia that when there were no-fault injunctions, that would encourage a shift to legal channels. Can you tell us more about these findings and how no-fault injunctions affect users' behavior and choices?
Yes, thank you. We've done a lot of studying over the last 10 years in which we've been operating in countries that have no-fault injunctive relief regimes, and our statistics and research shows that not only does traffic to the websites that are actually illegal websites is that plummeted, but consumers then go to legal websites. And so we see an increase of between 5 to 12% to legal websites after we block in a certain jurisdiction.
That's great. That goes a little bit to Mr. McKnight's testimony. I want to shift a little bit. I represent the Research Triangle area of North Carolina, a number of research universities. And I want to highlight how digital piracy impacts scientific journals and threatens the security of American research. For example, Sci-Hub, an active private website based in Russia, has amassed over 80 million scientific journal articles, often by illegally targeting university websites in the US. Mr. Schurz, are you familiar with Sci-Hub, and do you know if your members, including AI developers, have systems in place to ensure that they do not obtain content to train AI systems from Sci-Hub or other pirated sites?
I'm familiar with the website, but I don't think I have enough information to answer that question right now. I'm happy to follow up for the record.
That would be terrific. And then for all of the witnesses, and maybe we'll start with Mr. McKnight because I haven't addressed a question to you yet. Have there been any international policies that have been especially effective at preventing consumers from cyber fraud that often results in engagement with piracy sites?
I think, the site blocking that we've been talking about has been demonstrated to be effective in certain countries, at least against professional pirates. I'm certainly not the expert in this area, and we're focusing more on expeditious removal and enforcement here in the U.S., so that's how I would answer from our perspective.
Mr. Gladstein, do you have anything to add, and then we can come to the other two? No. Okay. Mr. Schurz?
Yeah, I don't know that I have any more to add to that. Thank you.
Ms. Temple?
Yes, I would just add, that, again, we've noticed that site blocking has been effective, and, in our analysis of those harms that come to consumers that go to those sites, you're, for example, 4 times more likely to be the victim of credit card fraud, 4 times more likely to be the victim of malware, I think 30 times more likely to have viruses on your computers. So site blocking does help protect consumers. We were actually very pleased that we were able to work with the Department of Homeland Security and the IPR Center a few months ago to issue a PSA that talked about the harms to consumers from online pirated websites. So site blocking would be able to help that as well.
Thank you very much, Mr. Chairman. I yield back.
I think the gentlelady yields back. We now go to the gentleman from California, Mr. Kiley.
Thank you, Mr. Chair. Mr. McKnight, I appreciate your testimony and certainly, understand the harm that is done that is sort of unique when we're talking about live sports, that there's a real value proposition to actual live consumption. So, a remedy that is delayed even by an hour or so is insufficient. So we've talked about various potential remedies, maybe redefining expeditiously to mean instantaneously or near instantaneously. Could you help me understand kind of how the mechanics of this work? Like if there's a fight going on, how do you sort of in the moment find the illegal streams and then alert the ISPs?
Sure, there's a number of ways. I mean, some of the ISPs have automatic, to the extent you can identify, and digital the technology, depending upon how good the stream is and the quality of it, can identify it and pull it down. Where we have the issues is where we then have to identify and then submit these takedown requests. And then it's a question of how fast do they take action after that, after those requests are submitted. And we're seeing very, very uneven performance. In some areas, there's just non-responsiveness, and that's when you're seeing things like hours to days. And then with other, sites we've worked with, we've social media platforms that we've worked with, we've seen it happen 7, 8, 9 minutes. It's not terrible, but it's not effective. And most importantly, we know it's not the best they can do because it's it's been better. You know,
Right.
we've had conversations and seen things improve, but only momentarily, only to go back to sort of like the problematic practices that we observed long term.
You said that the ISPs, if the quality of the stream is good enough, they can find it. How do they do that? How do they?
They have technology. Like, say, if someone holds their phone up to a screen, you know, depending upon the quality of which that stream is put forth on a social media platform, for example, there is technology that can identify it as a problematic stream and then automatically take it down.
Okay.
Off of, say, you know, off of a social media platform of your choice.
So it's automatic. In other words, the technology identifies this as a copy, essentially, and there's no need for notice and takedown and for a person to approve it. It just comes down.
Correct. In those instances where that can be identified.
So is there a way to incorporate that technology, even on the provider side, where you could sort of include it in, you know?
Giving us access. Yeah, one particular provider has offered to do that, but many others haven't. But yes, I mean, you know, there are technological potential to develop that type of technology, and some folks have it already. They're just not putting their best foot forward. You know, look, without making accusations, the natural commercial incentive, you know, if you're running one of these sites, is the more users you have viewing content over your site, the better it is for you commercially. Right? So you don't necessarily have the incentive to put your best foot forward here. And if you look at the law the way it's currently constructed, it's not clear that we have a case that hours isn't expeditiously, or that even a day isn't expeditiously. The point we're making is if you're dealing with a live event as opposed to something like a movie, and there are other issues there that have been explained well by my co-panelists, that isn't expeditiously. It's definitionally not expeditiously not to take down something after it's already over.
Right.
You know, in effect, the commercial value of is gone.
I mean, is there any way to, I mean, I think there is a way. You could, with the technology where sort of it can just be scrambled or whatever, so you don't have to have an active taking it down per se. It's just that there's no, it doesn't actually, I don't know, Mr. Schurz, do you want to weigh in on that as well? Maybe you have some technical expertise. I'm just trying to understand the nature of what's available technologically so that can inform the best solution from a policy perspective.
The filtering technology is sadly not magic, and there's no metadata that says this is an infringing stream, although perhaps, you know, humans can determine from certain contextual clues whether or not something is authorized, although we can get that wrong too.
But how can you not make that, like if you have one authorized transmission, wouldn't any retransmission of that sort of be by definition unauthorized, so that couldn't be identified?
So there's a crucial piece of data there, which is what is the authorized transmission. And a number of leading services do allow and invite live sporting events to pre-identify what content is lawful. They may furnish hashes that allow for real-time filtering. But that does require data and inter-industry collaboration to ensure that the digital services have the tools to prevent the content from being ingested into their system. And of course, that all assumes that this isn't just a hyperlink to some site elsewhere.
Yeah.
Right?
Did you have anything else you wanted to add? Sorry, Mr. McKnight.
Well, I would just say in our case, we only have one legitimate authorized partner in the U.S., which is ESPN+. So if our live events are being shown anywhere else, it's definitionally unauthorized.
Right. Okay, thank you very much.
Thank the gentleman. Continuing with our California run, the gentlelady from San Jose, Ms. Lofgren.
Well, thank you very much, Mr. Chairman, and thanks to each one of these witnesses for their excellent testimony. Mr. Gladstein, no one is going to defend that infringing site, including me. I mean, to me, the only question is, how do we prevent this piracy? None of us should be defending it, and I include myself very much in that category. It was just 12 years ago that we had a very tumultuous markup in this room. I think just Mr. Issa, Mr. Johnson and I were here, and at the time, technical experts, the Internet Society and ICANN and others strongly advised against DNS level filtering or blocking, and instead urged that content level decisions be made at the network edge and not at the Internet's infrastructure core. And I think that probably continues to this day. So the question is, what are the best remedies? And I think that's something I would love to focus on, Mr. Chairman. One of the things that I'm interested in is when we've done a number of laws to help on this, I'd like to know how they are being administered by those charged with enforcement. For example, the Copyright Claims Board has the ability to take action as part of the CASE Act, which I supported. I don't know how that's going. I would like to know that. Obviously, that's not the major studios. Federal prosecution under the Protecting Lawful Streaming Act of 2020. What's been done on that? Has the DOJ brought any cases? I would like to know about that. The National Intellectual Property Rights Coordination Center, led by Homeland Security, is supposed to help with the Protecting Lawful Streaming Act. They have a center there. How is that working? I would like to know that as well. One of the concerns, I think that we're missing the boat, frankly, and I thought so 12 years ago when we had this tumultuous markup. These piracy sites would not exist if they weren't lucrative. They're making money, and that's why they exist. There are problems in terms of the effectiveness of trying to block IP addresses. There are technical issues that the internet engineers brought to a head 12 years ago, but there's no technical problem in preventing the funding. I mean, if you can't, if the credit card companies are going to be told they cannot process the funds for a variety of sites, these sites will go away. Now, there is a problem internationally, but the Open Act that I supported would have made the copyright trademark infringements an unfair trade practice and would have brought in the U.S. International Trade Commission as a partner in this. And I think even though sometimes we are not happy with their level of concern and sometimes they go in the wrong direction, it is a hook, actually, in terms of going abroad with the financial services component of this. To me, the answer has always been cut off the money and this will go away. So, you know, I'm interested, and Mr. Schreier, you're the only one here with, you know, speaking from technology, and I know that the chairman has said we're going to have other hearings on technology, but part of YouTube, for example, has gotten the digital file for various content so that they can take action when there's an infringement. One question I've had, and it's been problematic because you can make minor changes to that digital file and evade it. Have we explored, or is it even possible to do that kind of digital file on a broader basis? And would it work given the alteration that could be made? And then if anybody has a comment about cutting off the money, which I think is probably going to be the most lucrative, the most effective method we can, I'd be very interested.
Thank you for the question, Congresswoman. I think that's a great point. There is, among leading services and leading content providers, evolving strategies to share what we call hashes, which are sort of like digital fingerprints of a piece of content. And digital services will filter for that hash. And that's used both in the copyright context and outside of it. And it's a very effective way to intercept at the point of ingestion content that should not be in a particular place or should not be available for any number of reasons. Obviously, the technology is expensive. It has to be implemented in each service in a different fashion. But it is a very effective way to solve these problems at the front end. But it requires a lot of intersectoral cooperation.
Mr. Chairman, I see my time has expired, but I would invite the witnesses.
I'd ask you to ask the unanimous request that the gentlelady have one additional minute without objection, so ordered.
Thank you. I would just invite each of the witnesses to comment even after this hearing on the concept of denying access to financial rewards through the financial system, the credit card companies and the like, how we might work together to explore that. I know that, you know, we've got just a few minutes here and it's a deep subject. I would love to make this impossible to profit after.
May I make a quick comment?
Sure.
One of the issues with following the money that might not service this issue as well as you've just stated, quite frankly, is that many of these sites don't charge the customer anything to be able to watch that film. So what Netflix or Apple or anyone is competing with is the free dispersal of the product. The way in which those sites are making money is from advertising and from selling malware that they get from those that go onto their sites.
Right. So we'd have to
credit
go after
cards-
the advertisers as well.
So the consumer isn't using their credit card. They're just hitting a button. And the technology is such that the programming that they're watching doesn't look like someone sat in the back of a theater with their iPhone and copied the movie. It is a digital copy of the film that looks exactly like the film I just made. I couldn't tell the difference between the version that's on F-Movies and the version that's on Netflix. So and also Bitcoin is used often now.
Right.
There's various other ways in which these folks doing this illegal activity is doing other illegal activity and benefiting from those that are going onto their sites. So merely the credit card is not a solution. I don't.
Not all of it. Mr. Chairman, I appreciate your giving me an additional minute. I'll just close with this. I hope we don't get into another tumultuous, dysfunctional technical fight as we did 12 years ago, but I do think we have a lot of opportunity to look at enforcement, including DOJ, including potential financial cutting off, and I think the gentleman's testimony is enlightening, and we could spend a lot more time getting into this and maybe getting some real results. So I yield back, and I
thank the
you very much.
gentlelady. Those 12 years ago, the names SOPA and PIPA were bantered around, and we thought that that was going to be a solution without any debate. I can promise the gentlelady that we are going to invite all the parties. We are going to go through a process that at least makes sure that all facts and capabilities are known before any legislation goes forward. I have a history with several here on the dais of fighting against our own chair at the time and ranking member and against the Senate, and we won. But unfortunately, the content producers do not have a solution, and so I want to find justice at a fair rate, something that you and I fought against more than a decade ago, but we know we still need to protect the content producers, and so I look forward to working with it, and I promise an open and transparent process.
Very good.
I now thank the gentleman from Virginia for his patience and yield him.
Let me tell you, Mr. Chairman, thank you for the time, and I want to thank the gentlelady from California, because I wasn't here 12 years ago, but I was here 25 years ago, but I was sitting back there and watching the DMCA debate and watching the Telecom Act debate. And so this is fascinating for me, and I appreciate the gentlelady's expertise and all her work.
If the gentleman will yield,
I'm
I
happy
think
to.
the chairman, former chairman, and I may be the only members of this subcommittee who were here when the DMCA was approved, and obviously the technology has changed since that time, and so I appreciate your reference.
It has, and I want to start by agreeing with the gentlelady in her comments about DOJ. And in 2020, only 4 criminal copyright cases were charged. In 2021, only 5 were charged. Only 3 were charged in 2022. So we've got a ways to go, and I would like to have DOJ here and have the opportunity to get into a discussion with them about this issue, because there are so many different issues with DOJ that we have to discuss, that it's a challenge to cover everything you need to. And with this topic, I think having a specific hearing regarding the lack of prosecution would be helpful. But I also want to address your comments about the technology. You said 12 years ago that changes in technology might not be all that significant, but when you're talking about the internet, I mean, 12 years is a lifetime. And I would guess that there have been changes in technology that may make site blocking more feasible, more effective, maybe more targeted. Ms. Temple, can you comment on any of the technological developments in that area?
Yes, I think the main thing that we have learned over the last 10 years of working with these laws with ISPs is to work, again, collaboratively with them and provide them flexibility in terms of the use of technology. I know that there's been a lot of talk about, DNS level blocking, but that's not the only type of blocking, and that's not even the primary type of blocking that we're talking about. So when we, ask for site blocking orders overseas, we work with the ISPs, and they have flexibility in the law in terms of utilizing the most effective and most efficient and least burdensome type of technology, whether that is DNS blocking, IP address blocking, URL blocking. So that is one of the things that we found to be one of the most effective ways to accomplish it, is to work collaboratively with the ISPs and allow them the flexibility to determine how they will actually implement blocks that don't negatively affect networks.
Mr. Schurz, I'll give you the opportunity to respond there and talk about the technologies that are used.
It's critical to think about I'd say the first question we have to ask is at what level of abstraction are we solving this problem? And I'd say throughout the digital sector, there's an interest, a desire, an urgency about responding to piracy because in many cases these sites are dangerous. Of course, there's a lot of content interests within the digital sector, so everybody agrees this is a problem.
I want to go specifically to the technology, though.
Right. So as to the technology, if we're talking about broadband providers at the architectural level, I should make clear, those not principally my constituents, and I don't want to speak for them. I am aware of, and my testimony cites a number of problems with that. For digital services that are at the edge of the network, they, of course, comply with the Digital Millennium Copyright Act notice and takedown, and many go above and beyond that and do allow even live events to pre-identify URL-level filtering to ensure that URLs don't resolve.
How many takedown notices do CCIA members who operate content platforms receive in a given year?
I don't have that at my fingertips, but the number is in the millions, if not the billions.
Okay. And how much money is spent processing these takedown notices?
And I don't know that companies break that out, but they spend extraordinary amounts, not only on the processing by their trust teams, but on the development of technologies that go well beyond what they're required to do by law. I mean, tens of millions of dollars are being invested every year for some companies in their systems that don't just block content, but actually allow rights holders to monetize infringing uses of the works. And so in many cases, they're given the option to say, hey, I can leave this content up and get a share of the revenue if I so choose, or of course have it removed. And increasingly, rights holders choose to do that and get a cut of the ad revenue, which is a win-win.
Mr. Chairman, my time's expired. I'd just like to note that this hearing's focused on audiovisual, but copyright piracy impacts several industries, from movies to music to books to publishing. I'd like unanimous consent to submit a comment for the record from the American Association of American Publishers regarding the online copyright.
Without objection, so ordered.
Thank you, Mr. Chairman.
And if the gentleman would yield, I would share with you that I was not here in 1998, but I was chairman of the Consumer Electronics Association.
You were paying attention, yeah.
So we were paying close attention and working closely, if not collaboratively, with
Chairman,
the MPAA.
I do see a lot of familiar faces who might have been on this side of the dais, whether staff or otherwise, out in the audience, and they may be a little grayer and a little more wrinkled, but they are recognizable today.
And just as interested. I thank the gentleman. We now go to the ranking member of the full committee, Mr. Nadler.
Thank you, Mr. Chairman, for holding this important hearing. Mr. Chairman, not only do the creative arts serve to entertain and educate us, but they also support industries that contribute billions of dollars to the economy every year. Those industries exist because of the audiences that buy their final product. We as consumers want the inspiration, emotion, and diversion evoked by artistic expression. In exchange, we are expected to pay a fair market rate for those products, no matter the format in which we consume them. Intellectual property laws, including copyright laws, exist to foster creativity and innovation. They are a promise that with hard work and a lot of luck, you can monetize your imagination. But no technological changes challenge that promise like the advent of the internet. Even as technology helped us discover art beyond our small corners of the world, it made those creations easier to steal and thus less lucrative to produce. Copyright law is nothing without the ability to enforce those ownership rights. And it was with this reality in mind that in 1998, when the internet was still in its infancy, Congress passed the Digital Millennium Copyright Act, or DMCA, to protect copyrighted works online. But even with that landmark law in place, copyright piracy is still an issue that threatens industry stability and artists' livelihoods, and the problem is growing larger each year. I appreciate the opportunity to examine the issue of piracy, but as we consider any potential solutions, we should make sure we're looking at the problem not as it existed 25 years ago, but as it exists today. Copyright piracy now encompasses broad cybersecurity concerns, artificial intelligence considerations, and distribution changes like streaming services. Any action we contemplate must be flexible enough to stand not just the test of time, but also changes in technology that we cannot possibly imagine. Artists and content creators deserve to have their works and industries protected from illegal online piracy, and I'm grateful to Chairman Issa and Ranking Member Johnson for giving this issue the attention it deserves. With that in mind, I have a few questions for our excellent panel of witnesses. Ms. Temple, could you please help clarify the differences between IP address blocking, DNS blocking, and dynamic site blocking? When and how are each of these remedies useful?
Yes, thank you for the question. As I mentioned earlier, in most of the jurisdictions in which we operate, the site blocking order that is issued is flexible, so the ISP is just ordered to block access to the site, and the actual way in which that is done is up to the ISP. They might use DNS blocking, and they could use IP address blocking or URL blocking. In most cases, it's usually either DNS or IP address blocking. With respect to DNS blocking, it's typically, imagine, I guess, sending an envelope through the mail, and you have an address that you're looking for, and the ISP, the access ISP, is going to need to look for the address of pirate.com, for example, because they don't know the specific IP address, so they have to go to a DNS resolver and get the actual physical IP address, the 123.4.5 address for the website. And so in DNS blocking, the access ISP knows that they should not be going to look up the IP address for that site. Instead, usually they just disregard the request to go look up that site, so they can't get the address to that website. IP address blocking is similar, but it's looking at the IP address, so as opposed to the pirate.com issue, it might, if you know the actual IP address, the ISP will not actually allow access to the specific IP address that the website has. And then URL blocking is a little bit more complicated, but that is really they inspect the packet that's going over the internet and ensure that the very, very specific URL is not able to be returned back to the customer.
Thank you, Mr. McKnight. One of the primary challenges of enforcing anti-piracy laws is that the source of most pirated content is overseas. Could you please explain why this is significant and what policies, if any, can improve identification and enforcement of overseas actors?
So a lot of our enforcement efforts are actually based here domestically, because even though it is certainly true, as has been explained by my co-panelists, that a lot of the problem does start and originate overseas, a lot of the social media platforms and things like Facebook, Twitch, the usual suspects that we're seeing our content pirated over actually here is domestically in the U.S. So when we're looking for the definition of expeditious removal to be clarified, it's primarily to address that issue. The closing the streaming loophole, which was something that we got, you all helped us get past in 2020, has been tremendously effective. And I think with respect to that, it's all about enforcement, domestic or overseas, is getting enforcement against these career pirates, because unless they see folks actually going to jail or being shut down as a result of this legislation that's powerful and that's been enacted, they don't necessarily have a full incentive not to engage in the conduct. They pay attention to laws being passed. It's meaningful, it's helpful, but what's really helpful is when they see folks being caught and they see them suffering consequences.
Thank you. My last question is to Mr. Shears. Mr. Shears, sites hosting pirated content often endanger consumers through malware, cyber seams, and insecure connections. If, in your view, site blocking regimes go too far, how do you suggest we keep consumers safe?
So thank you for the question. Obviously, as I said, the best defense is a good offense, and making content widely available on as many platforms and in as many contexts possible is one of the first things that we need to do. Once we've moved beyond that, we need to look at inter-industry collaboration to ensure that digital services have the granular data and metadata about content to meaningfully pre-identify, for example, in the context of live streams, that something would be infringing, to filter upon ingest, and obviously strike arrangements such as those that I described earlier, where in some cases rights holders can choose to monetize instead of simply prevent. So there's a lot of options available. And then, of course, we have the existing panoply of remedies that are available under existing copyright law. Statutory damages, actual damages, all the extrajudicial relief that's available under Section 512, to say nothing of technological protection measures and small claims. There's probably more remedies in the Copyright Act than many of our other IP laws. So we have a lot of robust tools at our disposal. There are many arrows in the quiver that we can use. To be clear, we're only raising concern about one specific arrow in one specific context when we raise concerns about DNS-level site blocking.
Thank you. Mr. Chairman, I thank you for your indulgence, and I yield back.
You have always granted me similar indulgence. I thank the former chairman and ranking member. Now for me. Mr. Shears, I've found it interesting that one of the things we haven't gotten too much into is Mr. McKnight's question. From your knowledge, technical knowledge, forgetting about how something is blocked, when Mr. Knight puts in a notice and takedown, is there any reason that it should not be able to be done in single-digit minutes, as it sometimes is, or even faster today, based on technology?
So the ability of a given service is going to respond to takedowns is going to vary depending on the context, the nature of the work, the scope of the takedown. You know, it's not uncommon for a rights holder to submit millions of URLs, some of which may not be accurate. And because every takedown does terminate access to expressive content, there are consequences for getting things wrong. And so I know many services are instantaneous. A lot of services that allow rights...
Wait a second, I didn't ask that question. I only asked, is there any technological reason that it can't be done instantly?
When access to content is terminated, if you remove...
You're getting into the ramifications. Maybe I'll clarify my question. If we, I think, can all agree that the technology using AI is available for Mr. McKnight to submit, for it to be validated against metadata comparison if he's making that data available through his live stream, the idea that it can be compared and identified and taken down essentially without human interaction would seem to be unequivocal. So it sounds like there may be administrative reasons that an entity can respond to why they're not taking it down. But as the entity that created the original notice and takedown and the entity that can update it, as Mr. McKnight is asking us to, is there any reason we shouldn't update a requirement that it either be taken down using that technology, which is near instant, or that he or any company receive a response within the same period of time as to that which delays it? That's what I'm asking. It's much more narrow than the other subjects we're talking about, because we're not talking about do you have the capability. We're assuming the capability exists because it does exist for notice and takedown. What is your response to that? Either do it or respond near instantly.
I think we agree that an expeditious response is appropriate, particularly where there's economic consequences like have been described. And of course, Section 512 already requires expeditious response. There has been some litigation about what that means in practice.
Well, we're real good at eliminating the need for litigation by redefining to the courts what we really meant. It sometimes saves the court a lot of trouble. Let me just go on with another round of questions. Ms. Temple, you've heard a lot here, and you certainly saw us say we don't want to have SOPA and PIPA revisited. We want to have full and complete. But, and I want to leave free speech in another bucket, but I want to ask you a question. Based on the actions of these internet providers of using their protections under 230 to regularly take down infringing content that you often see, in other words, Mr. McKnight and others, and even Mr. Shears has said that providers do it, what lawyers say, sua sponte. They do it without a complaint often, and they do it with a reasonable protection. If they can do it without a complaint, as they often do by matching, is there any reason that we shouldn't encourage them to do it more often or substantially all of the time?
Yeah, if you're talking about filtering and ensuring that illegal content is not posted up on UGC sites, that is something that, certainly we want them to do more of, and we want to have more automated ways that you don't have to send the millions and millions of notices that the other witness mentioned. With respect to dedicated websites, of course, it's much, that are dedicated to infringement and are not UGC sites where people are posting. It is much more complicated because those websites are not going to take down the infringing content. They're not going to filter it out because they're dedicated to piracy.
Well, let me close with just a couple of questions. And Mr. Gladstein, I haven't asked you any questions, but I'm going to ask these questions in a sense on your behalf as a producer of content that finds himself somewhat harmless or harmed without any ability. I might note that one time I had dinner at a large banquet, but we were at the end of the table, and it was Francis Ford Coppola who bemoaned how little control he had over Godfather 3, and if he'd only had more control, how much better it would have been. So it's not just the fire and forget. Sometimes it's even when you're producing it. But Ms. Temple, because you have this unique expertise on both sides of it, why don't I just ask a few simple technical questions? To the best of your knowledge, when somebody imports a tangible product that violates IP rights, including patent, trademark, copyright, does the U.S. Customs have the authority to stop it?
Yes, it does.
And when a court or the ITC issues either an exclusion order in the case of the ITC or injunction in the case of Article 3, do all federal agencies have the ability to use their powers to stop the importation of those products?
Yes, yes, they do.
So today, as a closing question, aren't we just talking about finding the equivalent of what for 200 plus years our customs and other agencies have done when there is due process and entities such as Article 3 courts have reached a decision? The execution of that protection is done by our government or on behalf of our government by orders to those who participate in bringing things into the United States.
Yes, I would agree. That's a very similar process.
So as we invite the Department of Justice, which was suggested, and as we re-invite those who chose not to be here today, those who can talk to us about and Mr. Shears, I appreciate your expertise, but I want to have more of those entities in here to talk about what is technically possible, not just what is technically difficult, because it is this committee's jurisdiction and this committee's decision that which we protect through our ports of entry when a DVD comes in bootleg, we must be able to protect on the internet. If we do not have that ability today, it is our responsibility to create that ability. And I want to close by just making one statement. I know there have been good faith negotiations that have gone on behind the scenes. I have been told that those negotiations broke down to a certain extent because of hold harmless questions in our very litigious society. It is also the jurisdiction of this committee, at the full committee level, to provide that type of protection. So let's be clear that in getting it, I'm aware that if you get a court order and Customs seizes DVDs coming into the country, everybody's held harmless. There is, in fact, a government right to do so, and all you can do is maybe get your DVDs back later if there was a mistake. You don't get to litigate against the person who brought the claim in court. What is possible in the tangible world, I want to put on notice those that we're going to have in follow-up. We want to find a solution in the internet world, and we will not quit under this committee, and including my ranking member to my left and my full committee ranking member also to my left, until we do so. And with that, I want to thank our witnesses, and I want to thank all those in attendance who often represent people who did not speak here today. With that, we stand adjourned. Oh, I'm sorry. All members will have 5 days to issue questions, and I would ask the witnesses, would they respond to written questions if they receive them?
Yes.
Thank you. With that, we stand adjourned.
Thank you.